I was saying more about daily update TV. So, and then I will share and subscribe. And then Supreme Court kwasetena. The kind of a live briefing be abetum nabusia. A year NDC for legal head of council. A year Ejuji Tamakulu Godwin. Now, evidence our presented before the court is a very superior concrete evidence. Now, we as my Lord, I therefore call you to quash the decision of the Supreme Court, because a Supreme Court, the High Court, for High Court, any margin mensa go ahead while there's injunction filed in the Supreme Court. Abusia, it's equal to legal council Ejuji Tamakulu before them no just say and some evidence what they might ya nyabotara capture the ato dwumadi ntiti dwumadi no ne hu baby ensem ne ko they are still yet to decide. Into omu tie the hearing of the both parties into go tie council Ejuji Tamakulu na in conclusion was my lord where the evidence and the fact question the decision of the the High Court and dementia as well. Now, this is a very, very beautiful moment of the Supreme Court and Ejuji Council, Ejuji Tamakulu. God bless you. Stay tuned, stay connected.
That we had all appeared before the judge and gave us 2 days.
My Lord, this is not before the court.
Okay. So you haven't deposed.
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My Lord,
you were addressing us on what you said is the argument that
yes,
the declaration has been done already. So address.
My Lord, I have quick response. We urge on this honorable court to quash the orders of the High Court General Jurisdiction 13 My Lord, maybe just a quick point. In paragraph, my Lord, with respect, in paragraph 10 of the 2nd to 7th interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed. Yes. My Lord, with the greatest respect, the gender application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about you. What you are alleging, my Lord, is not captured in affidavit.
Is that paragraph what?
Paragraph where you said the joinder was heard. A joinder which was not on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. And I'm saying that we were not heard.
So it's different from saying that
we were not heard. My Lord,
the one in respect of Nana Akuya Owusu Afri.
My Lord, I want to just locate my.
I believe it's Newz affidavit.
Okay. No. So, my Lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My Lord, within this context, a failure to do that, my Lord, will be a serious affront. That affront to the rule of law, constitutional. This breach has constitutional objection to the non-compliance.
Party may raise it.
Yes, I'm saying that without that, this court is required to consider it. Yes, my Lord. To the nature of the bias, that in one breath he holds us strictly to the rule, and my Lord, that is even denied. The gender application had a certificate of exhibit with the greatest respect attached to it. Yeah. Yes. Yes. So, my Lord, I'll just read the ruling.
Oh no, which one? On your non-compliance with the rule?
No, the issue of the manifest bias.
Okay.
My Lord, Exhibit B series, ex parte are not on prayer.
Yes.
My Lord, there was no exhibit attached. So the issue of certificate of exhibit does not even arrive. But my Lord said we had offended the rule.
Okay.
My Lord, 2. Ex parte Nana Ekwia Owusu Efriye. That one we attached a video recording of the declaration, and there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. My Lord, I want to bring to your attention the decision of this court in the Republic versus High Court Bogatanga. Ex parte Hawa Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because
proceed.
Because the applicants were not parties at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched, because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in ex parte Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
My Lord, the point we are making is that, with the greatest respect, my Lord.
Yes.
One, he does not attach any official record or official document to the deposition, or a police report by any of the returning officers detailing the so-called arrest or fraud.
That weakens the weight.
Very well.
I don't think we...
No, my Lord, I just want to bring it to you
okay.
that those depositions should not be responded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter. But you can't, don't say we should expunge it.
My Lord, the respondents say they had already done the collation. And so what is the point, you considering our application? My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Judicial 6 with my learned senior Justin Amenufo and Gary Limaku, where there was a pending injunction application against the Electoral Commission. That my Lord,
my Lord, so far, various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel. We have a.
Please restrict yourself to your affidavit and let's go on.
Yeah.
Yes, my lord. So, my lord. So our response is that at all material time, there was a pending injunction application.
Thank you, counsel, for
I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother, now retired Justice Badegbe, delivered the ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my Lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read.
CI 47.
Of CI 47, my Lords. No proceedings shall be defeated by reason of misjoinder or non-joinder of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My Lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
But it was not a writ. Why do you talk?
No, that's why I use the word even if. Okay. Even if we do that, the non-joinder will not defeat the proceedings. The court has a right.
You argued Hawa Yakubu.
Yes, my Lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My Lord, the order doesn't apply on all four simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joinder. But you can question it on other parties.
Yes, my Lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my Lord. And then also, one last thing, now that you have brought it up, my Lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my Lord will look at it as an application. My Lord, there is an application because of the way the numbering is managed. I'm not able to before the court has made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimako.
Valos, we are also opposed to this application. We filed a plea opposition on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. Malos,
that was being discussed by Georgina Wood JSC Ash then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the audio alterum pattern. So, yes, if it comes, your point holds. But also address the area of the failure to observe the audio alterum pattern rule.
Yes.
You have argued it, but I think you should expatiate on it.
My Lord, we stop it. That the non-party right to fair hearing has been breached. As party, Daso, and others.
As for sexual rights, they are public law release. You don't have to be a party. And then we have.
My Lord, this is about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternatives.
Abusia, yara sew koso ehwe dwumadi no. Yeso so be subscribe, share na comment no so. Fashion comment section e be bre na ya kan meti fo ene hwefo nyina ho adwenkyere. De e koso e wo Supreme Court no no. Je say NDC for ayeden akọ presente omo case no e de ama the Supreme Court say eye abra na omafale injunction e de ato Re-Collated so na MPP for any high court omo decision e baaye na omo ye den ka say ya maame eye Jimensa onye den wonko ahead no nko ye Re-Collated while emera no so eden 8 year abusia we ni enshama chese eye the rule of eye Supreme Court no omo discuss and the nyamisha ni stay tuned, stay connected.